I'm attorney Zach Townsend from Pro Legal Care, here today to talk to you about guidance for your divorce trial. If you're going to trial on your divorce, that means that you have not been able to settle the case, that you've exhausted all so-called amicable remedies, and that now we have a bona fide contest that needs to be ruled upon by the judge over one or both parties' objections. You never know what you're going to get when you go to trial, so it's important to be prepared, have good expectations, realistic expectations, and to know what to expect. When you go to trial, normally the first thing the judge asks both parties is, are you ready to proceed? That's the point where you would identify any issues, problems, witnesses that cannot appear, continuances that need to be addressed, or anything else that might have caused a hang-up for the trial to be able to not occur. However, if this is the day of trial, and you say you need more time, if this is the day of trial, and you say, well, I still haven't gotten that bit of evidence yet, or I'm still waiting for this document to come in, the judge is going to be none too happy that you are bringing this up on the day of trial. It doesn't mean that your continuance won't necessarily be granted. However, it's something that you really want to get out of the way ahead of time. So if you have issues that cause a hang-up, if you have issues that necessitate a continuance, or problems with information that you need, or evidence that you need to obtain, or having your witnesses available, you want to make sure that that is addressed ahead of time and not on the date of the trial. Another preliminary issue, as you might call it, that is addressed at the beginning of the proceeding as you proceed to divorce trial are called motions in limine. Motions in limine are motions that are right at the limit before trial. Oftentimes, parties will make a motion to exclude certain evidence, to make some kind of predetermination or something of that nature. Another common motion that you will see at trial is a motion to exclude witnesses. If there's a party in the case, maybe it's a loved one or family member of one of the parties that's there present in court. Yes, it's an open public hearing, public courtroom, but if that person is going to testify later, then they should not be present at the trial when it begins. The only parties that are permitted to be present at the trial before they provide their testimony are the parties themselves, the petitioner and the respondent. After your friend, loved one, or whomever who is a witness provides their testimony, if they're not going to be called as a witness again, they usually are allowed to stay in the courtroom. That has to do with the motion to exclude witnesses. The petitioner goes first when the trial gets started. Usually, the parties have the opportunity to provide opening statements. Opening statements are what you tell the judge that your evidence will show. Opening statements are not arguments. Opening statements provide the court what you think the witnesses will show and why that supports the outcome you want. That's an opening statement. Each party has the opportunity to provide an opening statement. Oftentimes the judge says, let's cut to the chase here. I want to hear from the witnesses. Are you willing to waive your opening statement? And oftentimes parties do that in a divorce case, but oftentimes not. It depends on your judge. After that, the petitioner calls all of their witnesses. One after another, the witnesses are called. There's an opportunity to cross-examine the witnesses by the opposing counsel or the opposing party after each witness is called. They're called consecutively, and then after the petitioner calls all of their witnesses, well, then the petitioner can rest their case. Then, the case in chief of the respondent begins. The respondent calls all of their witnesses, one after another. The petitioner or the petitioner's counsel have the opportunity to cross-examine the witnesses of the respondent. Thereafter, there might be some opportunity for rebuttal, and then closing arguments are provided. After closing arguments, the judge makes a decision. The judge's decision will be based on the evidence and the law. The judge may make the decision right then and there. That's called ruling from the bench. If the judge decides, hey, I want to take a look at my notes, I'd like to review these exhibits, I'd like to think about it, sleep on it, then the judge will set a future date for decision. And that's called taking the matter under advisement. If the court or the judge takes the matter under advisement, it means you won't get a decision right then and there. Sometimes that happens. Another problem with a trial that might be disappointing and related to delay is that maybe one or both parties haven't gotten through all their witnesses. And then 4:30 comes, it's quitting time, everybody goes home, and then everything is reset to a later date, which might be months away. So that's a concern too. So make sure that you mind your time. That's a little bit about preparing for the divorce trial and what to expect.